So you need a few minutes, we can do something else.
Yes, Your Honor.
All right, that's fine.
Thank you.
We'll move to the all-purpose criminal calendar. Position number 1, indictment 22 SC 182298, Janice Dillard. All right, we'll hold. Position number 2, indictment 22 SC 182298, Russell Green.
Judge, he's here. I'm not sure if they're still gatekeeping.
All right. Position number 3, indictment 22 SC 185220, Terry Relaford.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Relaford. He's present with us by way of Zoom.
And who's the ADA?
Judge Frank Marquez on behalf of the state. I'm filling in for Miss Washington today.
All right, Mr. Mackey, we're here for case management. So where are we on this matter?
That's correct, Your Honor. We have received discovery. I've not yet received an offer, but I understand Ms. Washington is currently in trial, so we're going to circle back when she gets out of there. But this case is ready to be put forward to a final plea calendar.
All right, we'll move it on to a final plea calendar. You will be notified of the next court date. And if there's nothing further, all parties are excused.
Thank you, Judge.
Thank you, Judge.
Position number 4, indictment 23 XC 191773, Jeremy Malone.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Malone. He's present with us, but he's in custody.
Position number 5 is also Mr. Malone. Indictment 24 SC 003090. Mr. Marquez, are you representing the state on both these matters?
I am, Your Honor.
All right, they're both on for case management. All right, good morning, Mr. Malone. We're here today for case management. Mr. Mackey, where are we on position 4? And then we can move to position 5.
On position 4, we have received discovery and an offer. That case is ready to go to a final plea calendar. And Your Honor, I believe that these are already scheduled for final plea in January.
Yes.
So we're expecting to do that on position number 4.
All right, position number 5 is indictment 24 SC 003090.
And Your Honor, for that case, we have received discovery this morning. There was an issue with an interview that wasn't playing nicely with the evidence.com, so the state has kindly provided me with a USB that contains that file this morning. This case is also on for final plea for January. I am going to review the interview, and if I have any additional motions, I'll file them by the end of the week.
All right, thank you. Anything from the state?
No, Your Honor. And we did extend an offer on both cases, Judge, just for the court's information.
All right, so we will look to see you all in January for final plea. If there's nothing further, all parties are excused.
Thank you, Judge.
Thank you, Judge.
Position number 6, indictment 24 SC 004656, Kevin Mercado.
Judge, they're also Mercado. He only speaks Spanish. I requested a Spanish interpreter. I sent Mr. McKeon an email about that. I don't see one yet.
All right, we'll have a seat. We'll come back to you.
And also, Judge, position 2, Russell Green, they've let people now in the courtroom. So he's present if you wanted to return to that one.
Position number 2.
Yes, Judge.
All right, position number 2, indictment 22 SC 182298, Russell Green. Mr. Marquez, are you representing the state?
I am, Your Honor. Just so the court is aware, the state is going to be submitting a malcost on positions 1 and 2. I thought we had already done that, but clearly not.
All right, Mr. Green, the state is announcing that they are no longer going to pursue this case against you, and they will be submitting a null process order for the court's consideration. Thank you for showing up this morning. If there's nothing further, you are excused. Position number 1 is indictment 21 SC 182298. Mr. Marquez, is that your announcement for that indictment as well?
That's correct, Judge. Just so the court remembers, this is the one where the third defendant, the other third co-defendant took responsibility for everything in the house.
All right, so that case is null process as well.
Thank you, Judge.
Position number 7, indictment 24 SC 004525, Xavier Rainier.
He's in custody, Your Honor.
Ms. Jones, is that your client?
Yes, Judge.
Mr. Marquez, are you representing the state?
I am, Your Honor.
All right, it's on the calendar for plea and arraignment, so bring out the defendant, please.
Judge, I also filed a motion for bond reduction on that one.
It's not listed on the calendar.
Because she put the calendar out before I filed it.
He has a...
She put these calendars out a long time ago. I filed it,
Right.
And Judge, I would, and with all due respect to Ms. Jones, I would ask to have that set on a calendar or a specific calendar so I can bring in the victim. The victim deserves to be here.
I filed it on November 20th. I sent copies of it to everybody.
Does that include Mr. Marquez?
Yes, of course it does.
You said everybody. I don't know who that includes.
Well, it includes the relevant parties, Mr. Marquez.
All right, so
And the case
Mr.
manager.
Marquez, Ms. Jones is asserting to the court that she gave you a copy of her notice.
And if she electronically filed it, I don't doubt that at all. The only thing being, Judge, because it's set for a plea and arraignment, not necessarily a bond reduction, that's the only reason that I would ask for a particular date on that.
All right, so let's deal with plea and arraignment, and according to you, Ms. Jones, he already has a bond, correct?
He has a $10,000 bond, but the bond order reads $11,000. So yes, he does have a bond.
All right, as to indictment 24 SC 004525. We're here for plea and arraignment, Ms. Jones. What are we doing?
Waive formal arraignment under a plea of not guilty.
All right, so the court will enter a scheduling order. You will be notified of the next court date. Ms. Jones, I'm going to come back for the bond reduction and give Mr. Marquez an opportunity to reach out to the victim. So we're going to hear it today. We're just not going to hear it right now.
I hear it today? Okay.
Yes.
I understand. I was just clarifying, Judge. Let me say this as well. There is a non-complex case that should have already been transferred to this courtroom. I'm not sure why they're dragging their heels. That case number is 23 SC 191544.
Non-complex does what it does. Delay, delay, delay.
Well, it was already delayed when I picked up this case, and I've been in communication with them for a while, and I can't figure out why they haven't submitted that. And I'm concerned about that one because that one is a criminal damage to property in the second degree. The discovery I see in the file from the non-complex attorney suggests that it's a misdemeanor at best. And he's been in custody for quite a long time. You've been in custody since May of 2023?
This-
2024?
Yes.
He's been in custody since May 29th of 2024.
6 months.
And then he did some time on that case last
On the
year.
24 SC 004525 or on the 23 SC 191544?
He got picked up on the 24 case, Judge,
Okay.
and then he's also being held on that 23 case.
They never set a bond in the 23 case?
He has a bond, and that's been reinstated.
All right, okay.
And Judge, just so the court is aware, and there was an ex parte filed on the 23 case. So it was under judicial hold status for a little bit.
Right, and when I got the file, I met with my client, determined that that request had been made in error. It's been withdrawn, and so it's ready to come here. I'm not really sure what they're waiting for,
All right,
but there's been a
well,
lot of dragging their heels on that case.
you can look into that while we wait for Mr. Marquez to speak to the victim,
Okay.
or have someone in his
Come back
office
up.
speak to the victim.
Thanks.
All right, position number 8, indictment 24 SC 004916, Rodney Jackson. Who's representing the state?
Judge, that's Mr. Wittenauer's case. However, for purposes of this calendar, I'll make the announcement.
All right, so this is on for plea and arraignment. Ms. Jones, what are we doing?
We're going to waive formal arraignment, enter a plea of not guilty.
All right. The court will notify the parties of the next court date.
Thank
A
you, Judge.
scheduling order will be put in place.
Thank you, Judge.
If nothing further, all parties are excused. So we're going to move to the final plea calendar, indictment 23 SC 186907, Marquisha Knox.
Judge, she is present today. I'll ask her some time just to go out and retrieve her.
All right, let's go to position number 2, indictment 22 SC 185436, Jawan Gaston. I don't see Ms. Rondon, so we'll come back to that. Position number 5, indictment 24 SC 001933, Javion Outlaw.
Good morning, Your Honor. Camera back, yeah, Mr. Outlaw.
Is he present?
He,
Okay.
and Your Honor, this is on for final plea, and we have a negotiated plea. I was in the middle of completing paperwork when Your Honor came on the bench, so if I could finish the
Go
paper.
ahead.
Okay, thank you, Judge.
That'll give me enough time to go call my victim on that other case.
You ready?
Oh, Your Honor, I'm sorry, I still,
Oh, okay. Not a
I'm
problem.
going to follow.
We have other cases.
Attorney Sharp. Yes, please.
Go to position number 6, indictment 24 SC 001711, Beverly Range. Is Ms. Rondon? Okay. Let's try position number 3, indictment 22 SC 185439, Jaquila Carter.
Judge, I'm going to try to get in touch with him. I expect him today.
All right, position number 4, indictment 24 SC 001756,
Custody?
to Sean Hodge. All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay. Good morning, Mr. Hodge. This is indictment 24 SC 001756. Ms. Jones is present representing Mr. Hodge. Mr. Marquez is representing the state. The calendar reflects we're here for a final plea. What are we doing, Ms. Jones?
Mr. Hodge is going to maintain his not guilty plea, Judge.
All right.
Just
Any outstanding issues, Ms. Jones?
not that I can think of right now, Your Honor.
All right. With that being said, you will be put on a trial calendar and be notified accordingly. If there's nothing further, all parties are excused.
Yeah.
All right, let me go back to that.
Judge, can I have 2 minutes to?
Sure.
If I can. Thank you, Judge.
Is Attorney Lewis present in the courtroom?
I'm sorry, Your Honor.
Lewis?
Yes.
Okay, before you arrived, the state announced that on indictment 22 SC 182298, Janice Dillard, that they are going to null process that case.
Judge, of course you know I have no objection. And it is good to see you. I saw the meeting here and I said, oh, they did you on the bench too. And he told me it was for something else. So.
Of course.
Judge, is it possible to have this matter sealed without a formal motion, or do I need to send that? I can do that.
As long as the state isn't objecting, so you can get with the state.
Okay, I'll do that.
Mr. Marquez just stepped out, but you can send him an email or follow up.
Yes, ma'am.
I don't think it'll be a problem since they're not proceeding.
Yes, ma'am. Sounds good. Thank you, Judge.
All right, there's
My
nothing.
business being concluded, my client and I be excused.
I was just about to say, unless there's something further, all parties are excused.
Thank you, ma'am.
All right,
Have a great day.
you too. Deputy Hudson, let me know when something's ready.
I will, Your Honor.
And go do something else. Forgot. Right. Oh, there you go. It's a fish out there. Now it's Council Christmas.
doing this.
That's nice.
It is today, because John's stuff, but either way, we're withdrawing the motion.
Okay.
Sorry.
So you just need that much.
Yeah, so that he knows, his attorney knows, and she knows that we're not actually gonna hear that today.
May have a plea on Hodge. Not negotiable.
Minimum is 10.
Thank you.
Well,
I didn't know that.
armed robbery. Well, I mean, you should.
Huh?
Unnegotiated?
Huh?
It's like,
Well, I mean, he knows what the minimum is too, so. That's what, obviously, that's what you would be asking for.
well, you're not that far apart.
I'm unfair to play though, because I just spent an inordinate amount of time on Taylor Boulevard. I was like,
I'm aware, I was in the back.
Nothing wrong with it.
I gave you the sheets.
Yes.
That's probably. Oh, that's what it is.
She came, she's been there like 15
Excuse me, is Attorney Matthew available?
He's in the back. He'll be there in a minute.
Okay. All right. His client would like to speak with him in a breakout if it's possible.
Which client?
His client name is Range Copeland. here at ACDC.
Okay.
Thank you.
Sorry.
If you're good, all good, so you go ahead, I'm going to take it, I'm ready, so you can start. All right, you sure?
Ms. Copeland, can you hear me?
Go ahead, Attorney Mackey.
Okay, Ms. Copeland, because they didn't bring you over today, which is fine, I'm gonna have to come back out and see you before the end of the week, okay?
Yes, sir.
Okay.
Attorney Mackey, this is Officer Milton. Is when the judge comes back on the bench, are we going to be seen right away? Because I have another court that I have to attend.
I can let the judge know.
Okay, thank you.
All right.
You're good?
Carlos not learning. Carlos was quick, he said, I'm calling me to speak to learn and see.
You ain't got it yet.
You gonna stay right here, Mr. Spear? Okay, we'll look right at that one.
Who coming on, next,
You doing yours first?
The deputy at ACDC was asking that we,
Who is that?
position 7 on the final plea calendar, sorry. That's the deputy over at ACDC was asking that we do it. Malika Randy? No. No.
Who's the plea? Easy. Or what's the plea?
Remain seated, court under order.
Is Ms. Jones, we have an interpreter, so are you ready with your case, Mr.
Your Honor, the deputy who has the inmates over at ACDC was asking that we take up that position next because they had something. It's an announcement on the
That's
position.
fine.
Okay.
You can bring that one up, person out.
They're on the screen, Judge.
Oh, they're on the screen.
Yes.
Okay, which position, Mr. Mackey?
Position 7 on the final plea calendar, Your Honor.
Position 7, indictment 24 SC 001711. Malachi Range Copeland.
Good morning, Your Honor. Cameron Mackey on behalf of Ms. Range Copeland. Ms. Range Copeland is present with us on Zoom. Can you hear me, Ms. Range?
Yes, sir.
All right, who's representing the state?
Hi, good morning, Your Honor. Abigail Potter for the state.
All right, thank you. So the calendar says we're here for final plea. What are we doing?
That's correct, Your Honor. It does say final plea. We had filed a motion to suppress a custodial statement back at the time, and we announced that at the case management hearing. At the time, the state was represented by Ms. Lauren McCauley, and they had made an announcement about a different motion that they were intending to file. Ms. Abigail Potter is very recent to the case with Ms. McCauley's departure from their office. So we did receive a plea offer this morning, but I am asking the court to schedule us for just a motions date and whatever motion the state has that they could file, and we could maybe hear both motions that day.
All right, anything from the state?
Your Honor.
Okay, so we will reset for motions. So the state has not filed a motion at this time. Is that correct? Okay. And that was what Ms. McCauley had represented, correct, Mr. Mackey?
My understanding is that it was going to be a 404B motion, but we'll see.
And she's no longer with us.
Correct.
All right, so we will reset for a motions date.
Thank you, Judge.
If there's nothing further, all parties are excused.
Thank you.
Could I make a quick announcement on the co-defendant? I know Ms. Rondon is not here, but this case was, or this defendant, it was dead docketed. She was in the last stages of her life, and she was transferred to hospice. And so that defendant was placed on the dead docket, I think, with the idea that.
Okay, hold on. This is indictment 24 SC 001711. Beverly Range is the co-defendant.
Yes, Your Honor.
Okay, you may proceed.
Ms. Range's case was placed on the dead docket due to her being transferred into hospice for end-of-life care. I think the idea with Ms. McCauley was that she would be null prost. And I would like to talk to Ms. Rondon to see just the status, if she's, how she's doing. But if this were to go to trial, I would imagine it's just going to be defendant position 7.
Okay, I'm not sure why Ms. Rondon is not here. She's always here. So just reach out to her and get an update, and we will reschedule.
Thank you, Your Honor.
All right, thank you. Ms. Jones,
Yes, Judge.
they have an interpreter?
Yes.
All right,
For Kevin Mercado. Position 6 on the
it is Kevin McCardo.
Yes, Judge.
All right. They can bring him out. That's indictment 24 SC 004656. And sir, if you will tell the court your name, please.
Juan Bernal.
All right. All right, sir, if you will raise your right hand, please. Do you swear or affirm that you will, to the best of your ability and in accordance with the rules that have been promulgated for translating Spanish to English and English to Spanish, do so to the best of your ability?
Yes.
All right. Will you explain to Mr. Mercado why you're here?
Señor Mercado, mi nombre es Juan. Yo soy intérprete del tribunal el día de hoy. Okay.
All right. So since we have an interpreter, I would ask everyone to make short sentences, allow him to interpret, and then proceed. And let him know if he has any questions to ask you.
Si usted tiene alguna pregunta, por favor, háganos saber si usted tiene una pregunta. Muy bien. I don't have any questions.
All right, Ms. Jones, the calendar reflects that we're here for plea and arraignment and a bond motion.
Yes, Judge. Mr. Mercado will waive formal arraignment and enter a plea of not guilty.
All right, the parties will be notified of the next court date, and we will enter a scheduling order.
And as to bond, Judge, he currently has a bond in the amount of $15,000.
15,000?
Yes, Judge.
Okay.
I'd ask for a reduction to $1,000. Mr. Mercado is 20 years old. He's not married. He has no children. He finished high school. That was in Colombia, where he is from. And he came to Atlanta about a year ago. In fact, he came with his older brother, who is the complaining witness in this case. And it was just the two of them when they came. And they lived together when they first came. But then some friction arose over a woman. Mr. Mercado's girlfriend ended up cheating on him with Mr. Mercado's brother. That led to the friction. Mr. Mercado, in fact, they lived together. Mr. Mercado moved out of the apartment that they were living in when he made this discovery. But they still worked together. And they ended up fighting at the place where they worked, which was at the arena. Prior to this, he has never been arrested before. And he was in the process of trying to find another job, so he didn't have to work with his brother anymore. Judge, his brother, this is before I even got on the case, wrote a letter. I'm not sure to whom, but I have filed it with the court. The upshot of the letter is that he is not in fear of his brother, that he wants his brother to be released, and that his preference is that the case be dropped.
All right, anything from the state?
Yes, Your Honor. Again, I did see the letter that Ms. Jones filed. However, without that being certified or an affidavit, it's otherwise hearsay. We have gone ahead and attempted to contact Mr. Mercado's brother. Now, of course, it's much like a domestic violence situation where a victim will generally change their tune after someone's been arrested. However, it is on video in the hospital after Mr. Mercado stabbed his own brother in the chest, almost killing him, that he was a violent person, that this is over a woman. We could have just talked about it. His brother denies the allegations that they ever cheated, or he ever cheated on him with his girlfriend. In either case, Your Honor, the state does believe that Mr. Mercado, if he's capable of stabbing his own brother in the chest, that he presents a clear and present danger to society. He is at a risk to reoffend, since clearly he cannot control his temper. I would venture to say that he is here illegally, which means that
Mr. Marquez, he already has a bond. This is a request for a bond reduction.
I understand.
So we
that,
don't have
Judge.
to go through all of that. Or do you oppose the bond reduction, and why?
Well,
But he already has a bond. The request is for the bond to be reduced.
And that's why I would oppose it, Your Honor, because we do believe that the bond, given the circumstances in this case, is appropriate.
If I may, Judge, it appears from the photographs that I was served that that he was injured under his arm, so not in the chest, but under, it looks to be under his left arm, and there was no threat to his life. He didn't almost die. I think that's an inaccurate way to describe the nature and the extent of the injuries.
Has anybody produced medical records?
No, Judge. In fact, I don't even have a police report.
We've requested them.
I have a warrant, is all that is.
Yep, this incident happened back in July. So the medical records at this point should be available. Okay, so I'll reduce the bond to $5,000 with the same restrictions. If there's nothing further, all parties are excused.
I'll submit that order to Mr. McKeon today.
Okay, thank you. Mr. Sharp, ready? You ready?
Oh, yes, Your Honor.
Okay. So we're back on the final plea calendar with indictment number 1, 22 SC 181814, Shannon Jackson. His attorney is present, and the state is represented as well. We also have indictment 22 SC 185532 and indictment 23 SC 188183.
Your Honor, before we get started, may I approach with something off the record?
State has to approach as well.
I feel like it results in this story. He probably is first, yeah, he probably doing cameras.
Yeah, he probably.
Yeah, he probably doing cameras.
I want to steal Stop. That's
That's what he doing. He missed us. Might see the court come to order. You see what I'm saying?
We're back on the record. Bring the defendant, Mr. Jackson, out, please. Good morning, Mr. Jackson.
Good morning.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON,
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
Do you understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
Do you understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
Do you understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty, acknowledgement, waiver of rights.
Yes, sir.
Approach the early.
I remember.
All right. And do you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client as well as formal reading of the indictment?
So waived both.
And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes, sir.
Which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you were under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced. as all these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon?
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. And at the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. Do you understand you entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2?
Yes, sir.
Do you understand that you'd also be entering a plea on Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by intent?
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon?
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm a northerner. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date as to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea?
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served, balance on probation, yes, as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for 22 SC 181814. Count 1.
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to...
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, which is a statute minimum of 1.
Okay.
So if we're going to get there,
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3, commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, Your Honor. Yes, Your Honor.
And count 1, 3 years to serve, commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188, 183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies, nor any residence, quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he is to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge, so there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer,
That's
correct?
correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with Probation PCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the suit. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to the probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alford plea or just a regular guilty plea. All right? So we're going to start with 22 SC 185532. The negotiated and recommended sentence is on count 1, the defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing. If we could put on the sentencing sheet that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you or the court what I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late, don't miss that appointment, because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right, so at this time, is there anything else from either party?
Judge, just Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily, so Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary. That's good.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right, if there's nothing further, then all parties are excused.
Thank you, Your Honor.
Welcome.
Your Honor, that concludes the business after probation is done between that and excuse.
Yes,
I can't see you tomorrow.
all right.
Judge, position 7 on the final plea calendar.
Hold on.
Excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
Sorry, Judge, Ms. Knox needed to feed the meter, the parking meter, when you first called the calendar.
All right, Mr. Marquez, is this your case?
It is.